Good afternoon, ladies and gentlemen. Good afternoon. Thank you. My name is John Blackman, and I'm your Master of Ceremonies for this afternoon's proceedings. Thank you for joining us at the International Seminar of the Inter-American Court of Human Rights, 166th regular session, entitled Impact and Challenges of International Human Rights Law. Without further ado, we yield the floor to the President of the Inter-American Court of Human Rights, Judge Nancy Hernandez Lopez, and Ms. Anika Jackson to commence this seminar. Judge Lopez, Hernandez Lopez.
Good afternoon to all. I would like to greet Honorable Ms. Anika Jackson, Solicitor General of the Republic of Barbados, Commissioner Roberta Clark, President of the Inter-American Commission of Human Rights, our dear colleagues, Judges Ricardo Perez Manrique, Eduardo Ferrer, and Veronica Gomez, Professor Diane Desierto, Faculty Director of the Master Program on International Human Rights and Director of the Global Human Rights Clinic at the University of Notre Dame, Mr. Gunjan Sharma, partner of Volterra Fietta Law Firm, Mr. John Blackman, retired Senior Forest Service Officer. I am deeply honored to be part of the opening ceremony of this international seminar, a platform that allows us to continue reflecting on a pivotal moment in the advancement and institutionalization of international human rights protection in our continent. As I mentioned this morning in my opening remarks, for the 166th regular session of the Inter-American Court of Human Rights, it is a great honor to be here in Barbados and in the University of West Indies. We appreciate the unconditional support of Professor David S. Berry and his team that provided the necessary logistics for our seminar alongside with other activities regarding this period of sessions. We are pleased to announce an important development within the framework of our current sessions. The Court will formalize a significant partnership with the University of West Indies. This forthcoming agreement signifies a pivotal step towards fostering robust academic collaboration and reciprocal exchange with this academic institution. Before addressing the scope of the seminar, it is crucial to remark the reason why the Court is here and our role in the Caribbean and the American region. The Inter-American Court of Human Rights frequently holds sessions outside its main headquarters in San Jose, Costa Rica, which is significant for several reasons. These itinerant sessions help the Court disseminate its legal work, reach diverse populations, and engage in constructive dialogues with national authorities and civil society. By engaging directly with various realities across the America, the Court connects with its true stakeholders, the people. Its current presence in Barbados offers an insight to its international processes. This session serves as forums for public hearings, contentious case adjudication, compliance monitoring, and advisory opinion discussions, such as the one we will be focusing during this week regarding the climate change emergency. The Court's proceedings are public, ensuring inclusivity and participation. The ongoing regular session here at the University of West Indies includes not only this international seminar on international human rights law, but as I mentioned, the public hearing on our current advisory opinion on climate change emergencies. In the realm of international law, the American Court of Human Rights possesses unparalleled advisory powers. Unlike its more widely recognized contentious jurisdiction, which deals with specific cases involving identified victims, The advisory function of the court focuses on interpretation of international human rights law without involving parties in a contentious manner. In this capacity, the court responds to requests from states or organs of the Organization of American States regarding matters of international law. These requests typically seek abstract interpretations of the American Convention of Human Rights or other pertinent human rights treaties. The court's role here is to offer insights into states' obligations under these treaties, thereby serving as a cornerstone of human rights law. The impact of advisory opinions, albeit less recognized, is profound and ensures through its wide participation that no individual voice is silenced or that any opinion lacks social legitimacy. Last year, as I mentioned this morning, Colombia and Chile approached the court seeking insights into the climate change emergency's impact in the protection and guarantee of human rights. To gain a deeper understanding, the court chose to hold sessions in Barbados and Brazil, aiming to directly assess the climate change impacts in the Caribbean and the Amazon. The court's objective is to leverage insights from various stakeholders, including academics, civil society, and indigenous communities, to inform its response on state obligations concerning climate change and human rights. Ladies and gentlemen, in this context, the purpose of this international seminar is to further the ongoing dialogue regarding the influence of human rights on international law and the broader region. In particular, I am pleased to introduce Judge Perez Manrique, our former president of the Inter-American Court of Human Rights, who will speak about the relations between the Inter-American Court of Human Rights and the Caribbean. Commissioner Roberta Clark, who will discuss the impact of decisions and work of the Inter-American Commission of Human Rights. Judge Veronica Gomez, who will comment on the impact of decisions of the Inter-American Court and Human Rights. Professor of Law and Global Affairs, Diane Desierto from Notre Dame Law Faculty, who will speak about emerging themes in international rights law. Mr. Gunjan Sharma, who will talk about international law and the connection to human rights associated with climate change. And finally, Mr. John Blackman will assist in the moderating and delivering the concluding remarks. During this panel, our esteemed experts and academics will delve into a thorough examination of the impact and challenges linked to the international human rights law. Undoubtedly, the influence of international human rights law in shaping fairer and more equitable societies worldwide cannot be overstated. However, this impact also comes with significant challenges. The effective implementation of international human rights standards often faces political, cultural, and legal resistance from sovereign states. Furthermore, the lack of compliance and impunity in the face of human rights violations pose persistent challenges to the full realizations of these rights in the practice. Despite these challenges, international human rights law remains a beacon of hope and a catalyst for social change. Through activism, legal advocacy, citizen mobilization, significant advances have been made in protecting human rights worldwide. The struggle for justice and equality continues, and it is essential for all actors, from governments to civil society, to work together to ensure that human rights become a reality for everyone. I am confident that this seminar will encourage us to remain steadfast in our commitment to advocating for human rights and help foster dialogue in the region. Now I hand the floor to Ms. Anika Jackson, Barbados Solicitor General. Thank you very much.
Thank you, Madam President, honored guests, and delegates. I'm delighted to open this international seminar, which is occurring on the eve of the 166th session of the Inter-American Court of Human Rights, one of the world's foremost international courts. As Solicitor General, I am honored that Barbados is hosting the Inter-American Court as it hears submissions on one of the world's most pressing and complicating issues, climate change. As many of you are aware, our Prime Minister is an advocate on this issue, given its potential disastrous impact for our nation. Today's seminar on the impact and challenges of international human rights law is also important. International human rights law is undoubtedly one of the greatest advancements in the rule of law, having emerged from the rubble of the Second World War. Since 1945, there has been a great liberation of states from colonial rule to independence, with Barbados attaining its independence in 1966. It is not coincidental that, at the same time, international law has freed itself from the doctrine that might makes right. Barbados strives always to support an international order based on law and not arms, based on rules and not demands. This has also been one of the great impacts of international human rights law. It codifies what St. Augustine of Hippo said thousands of years ago, and I quote, "A law that is not just is not actually a law." International human rights law also has had another very important impact. It has created a universal mirror for every nation. It is the mirror by which each nation can judge itself. As is written in the Bible, "Let he who is without sin cast the first stone." A country must look at itself first. It must look inwardly. International human rights law provides that lens through which we can examine and monitor our society's development. It provides that entry point for reflection on ourselves, our institutions, our governments. How we maintain the fundamentals as we evolve and grow as countries is all influenced by international human rights law, and it keeps us focused on expressing our better selves as people and countries. With that said, I trust that you will enjoy your time in Barbados. I invite you to sample all that Barbados has to offer, our beaches and cultural and historical sites, delicacies, as well as our hospitality. And we enjoy the great honor of, the great honor of being invited to host this court and today this seminar. I will now return the remainder of these proceedings to the moderator, Professor Berry, and to our esteemed panelists. I look forward to hearing their expert analyses of the impact and challenges of international human rights law. Thank you.
Good afternoon. If you'll allow me, I'll take all protocols as having been established. My name is David Berry. I'm a professor of international law and regional integration law here at the University of West Indies Cave Hill campus. I am delighted and honored to have been asked to moderate the present panel and to offer short closing remarks. I have also been asked to offer a very brief introduction to the Inter-American system for those of you who are not familiar with it, because we'll be hearing members of the Commission and the Court, and you might wish to know more about the relation between the two bodies. So I will give a very brief introduction, then I will introduce the speakers, and then we will go through the speakers, and they will have about 15 to 20 minutes each, and then we will wrap up at the end. So let me give a brief introduction to the Inter-American System of Human Rights. It's founded on three core documents: the Charter of the Organization of American States, the American Declaration of Rights and Duties of Man, and the American Convention on Human Rights. Now, the OAS Charter establishes a regional organization for the Americas, which deals with a wide range of topics and contains several organs, including, importantly, the Inter-American Commission on Human Rights. The Commission, which was established in 1960, is the charter organ which is tasked in promoting the observance and protection of human rights in all OAS member states, including those not party to the American Convention on Human Rights. OAS member states include the following 14 CARICOM states. So all of CARICOM except Montserrat, which is an overseas dependent territory. Antigua and Barbuda, Barbados, Belize, Dominica, Grenada, Guyana, Haiti, Jamaica, St. Kitts and Nevis, St. Lucia, St. Vincent and the Grenadines, Suriname, the Bahamas, and Trinidad and Tobago. All 14 of these CARICOM states are guided by the Commission with respect to compliance with Inter-American human rights, including the American Declaration. The Declaration, although not binding per se, constitutes an authoritative interpretation of the human rights protected by the binding treaty, the OAS Charter. Of these 14 CARICOM states, 7 are parties to the American Convention on Human Rights, and these are Barbados, Dominica, Grenada, Haiti, Jamaica, Suriname, and Trinidad and Tobago. You'll see that list is getting shorter. Of these 7, only 3, Barbados, Haiti, and Suriname, have accepted the jurisdiction of the court in contentious proceedings. Now, the American Convention is a comprehensive and binding human rights treaty, which, along with the American Declaration, is interpreted and applied by the Inter-American Court of Human Rights, which was established in 1978. In terms of roles, the Inter-American Commission investigates human rights complaints, mostly in the form of petitions, and makes recommendations to states to address them with respect to all parties to the OAS Charter. For those that have accepted the jurisdiction of the court, the Commission wears a second hat. It can take cases against states to the court. The court's decisions in contentious cases are binding as a matter of international law and must be complied with. Now, the court's advisory opinions, such as the one for which hearings commence tomorrow, are not binding per se. However, as highlighted by the President, they do represent authoritative interpretations of Inter-American human rights norms and may be relied upon in subsequent cases before the court or in national jurisdictions. So that said, that was a very short introduction, but just to put things in place for those of you who didn't know anything about the Inter-American system. But it now gives me great pleasure to introduce our panelists, who will present in the order as listed on the website and the order I introduce them. I will read all of their introductions at once, allowing them to take up the remainder of the time speaking. Each panelist will have between 15 and 20 minutes to speak, and I will indicate, I'll try to do so subtly to them when they reach the 15-minute mark, so they will know their time is running. And they have asked me to drastically edit their bios. I had very long bios for them, and they've said, no, and they said, edit these. So unfortunately, I apologize to everyone. You've asked me to do it, and I will do it. So first, I am pleased to introduce the Honorable Justice Ricardo C. Perez Manrique, a judge of the Inter-American Court of Human Rights from Uruguay. He obtained his PhD in law and social sciences from the University of La República in 1973, and in 1989 revalidated his academic degree at the University of Buenos Aires, where he worked as a lawyer. He has lectured at a number of institutions, including the University of Buenos Aires, on the UNICEF regional courses for judges, public defenders, and prosecutors on jurisdictional protection of the rights of children and adolescents at the Center for Judicial Studies of Uruguay, and served as a trainer for the UNESCO in freedom of expression, freedom of access to public information, and protection of journalists. He's given lectures and conferences globally. He has served on the Inter-American Court of Human Rights since 2019, including a term as president of the court. He served in judicial office in Uruguay from 1989 and has held numerous positions in regional and international legal bodies. He has received awards and distinctions, including twice receiving Doctor Honoris Causa. Second, I am pleased to introduce Roberta Clark, President of the Inter-American Commission on Human Rights, who hails from this lovely island of Barbados. Commissioner Clark was elected by the General Assembly of the OAS during its regular period of sessions in 2021 for a 4-year term. An activist for social justice and gender equality, Roberta has led UN Women regional offices in East and Southern Africa, Asia Pacific, the Caribbean, and Libya. Prior to her career in the United Nations, she practiced as a lawyer in Trinidad and Tobago. She is currently chair of the Harassment Committee of the Caribbean Court of Justice, and as I've said, is a citizen of Barbados. I see she's telling me to shorten it, so I will stop there. Thirdly, I am pleased to introduce the Honorable Justice Veronica Gomez, a judge at the Inter-American Court of Human Rights from Argentina. Justice Gomez is an Argentinian jurist with wide-ranging experience in professional and academic areas linked to international human rights law. And she has strictly told me, this is all I can say, she is currently president of the Global Campus of Human Rights, a distinguished network of universities headquartered in Italy with regional programs across the globe. Fourthly, I am pleased to introduce Professor Diane Desierto, Professor of Law and Global Affairs and Global Director of the Notre Dame Law School Global Human Rights Clinic. Professor Desierto joined the Notre Dame Law School in January 2021 as Professor of Law and LLM Faculty Director with a joint appointment at the Keough School of Global Affairs. She teaches, publishes, and practices in the areas of international law and human rights, international economic law and development, international arbitration, maritime security, ASEAN law, and comparative public law. And finally, I am pleased to introduce Gunjan Sharma, partner at Volterra Fietta. He's not here now, but he said he will come before his appointed time in the panel. He is an experienced New York qualified attorney specializing in complex international disputes and important public international law matters, holds a Juris Doctorate from NYU School of Law and a Bachelor of Science in Foreign Service from the Walsh School of Foreign Service at Georgetown University, Washington, D.C. He was awarded the title of Next Generation Partner by Legal 500. He has represented states before the International Court of Justice and private entities and states in numerous multi-billion-dollar investor-state arbitrations. He has served as an expert witness on behalf of the state on matters of sovereign immunity, public international law, and administrative law, and practices before a wide range of federal and state courts in the U.S., and as well as in international commercial arbitrations. There, I have shortened them, as you can see, considerably. So without further ado, I'm very happy to ask Justice Manrique to please offer his remarks. And I think you can do so from your seat if you wish to do so. Thank you.
Thank you. I will speak in Spanish. It is a great honor for me to sit on this panel with the President of the Inter-American Commission on Human Rights, Roberta Clark, with my colleague, Judge Veronica Gomez, also with Professor Diane Desierto, a professor at the University of Notre Dame, and I also want to extend my greetings to the moderator of this panel, Mr. Barry. First of all, I would like to thank the government of Barbados and this university and this West Indies University for having hosted this activity by the court to discuss the request for an advisory opinion on the climate emergency and human rights, which we will tomorrow, as you know, we will begin the public hearings and received more than 62 amici briefs in that hearing. In the second place, I would like to extend my greetings and congratulations to Roberta Clark on the 65th anniversary of the Inter-American Commission on Human Rights. I think that the Commission has done significant work over these years. It was the first human rights protection body in the region and has been working since 1959. After that, after the Inter-American Convention went into effect, the court then took part in this work. When we talk about the Inter-American human rights system, we're referring not only to to standard setting, rules setting, but also the institutional facet of the system for human rights protection. When you talk about these subjects, I always like to draw a timeline, if you will, covering the different documents or basic treaties of the Inter-American system for the protection of human rights, and to discuss the way these documents set the history and the lines along which the system has evolved and the basis on which has been built. In 1948, April of 1948, in Bogota, Colombia, the OAS Charter creating the Organization of American States was approved and adopted. The countries from throughout the region that worked toward the creation of the OAS understood at that time that the organization needed to be built on three basic pillars: the democratic state for the rule of law first, number two, affirmation of the democratic state and all of the freedoms associated with representative democracy and the rule of law, and finally, the fundamental affirmation of human rights. The conference therefore issued the first Declaration of Human Rights in the world, which in fact predated by 6 months the Universal Declaration of Human Rights. In the development of the organization, therefore, in 1969, the Inter-American Commission was created for the specific purpose of spreading information about human rights and to work closely together for the application and adoption of the declaration by the states. In 1969, the Inter-American Commission on Human Rights was created, and it is the commission that addressed the basic treaty in the region, which guides our work and sets forth the obligations of the states. And contains a list of rights, including civil and political rights, economic, social, and cultural rights, through Article 27. It also incorporates, adds into the new system with the new configuration. It incorporates, first of all, the Inter-American Commission, which is designed to be responsible for disseminating and working toward the application of the convention throughout the continent and throughout the hemisphere, and with a nearly judicial role, a very important one, which is that it orders precautionary measures, and it is the body that receives complaints of human rights violations brought before the system. This led to the creation of the Inter-American Court, which was created by the Commission itself and which began to operate in 1969. So this year, we are also recognizing the 45th anniversary of the creation of the Court, of the Inter-American Court of Human Rights. I always like to emphasize, when we talk about the documents that guide the system, emphasize the Democratic Charter, the Inter-American Democratic Charter, which is a document adopted in 2001, and under which all the countries of the region took on the commitment to work domestically such that the rule of law would govern domestically based on representative democracy, with the understanding that it is essential to adopt representative democracy in all the states in order to comply with the convention and the charter. The court began its work in 1969, as I said. The first judgment was handed down in the late 80s. That is Velázquez Rodriguez v. Honduras. In the early days, the court had basic jurisdiction, did not have jurisdiction. That is, direct jurisdiction. Cases coming before the court generally address the consequences of domestic civil wars and repression of protests and so forth. The work has evolved from those early days until now, when the court is dealing with cases and issues involving human rights that are much nearer and more direct. And this is why there has been such a great opening. First of all, recognition of vulnerable groups, even beyond those set forth in the convention. I would specifically point to LGBTQ plus groups, also groups such as the deepening discrimination against women and other vulnerable groups who unfortunately constitute a whole new category, in my view, that is the climate migrants, that is people who have been expelled from their land because of climate or environmental conditions. This is the court continues to judge economic, social, and cultural and environmental rights, and has been doing so since 2017, and its case law has been gaining ground as time has gone by. In this framework, then, the court, at the invitation of the government of Barbados, has made the decision to hold its hearing on this advisory opinion concerning climate change and human rights. Last year, the president of the court was dealing with this issue, and we felt that it was critical for this particular deliberation to take place, or the hearing to take place, in one of the places that are especially vulnerable to conditions that are particularly to the deleterious effect of climate change. Today, the court is in the Caribbean, and next month it will be in the Amazon region of Brazil. We understand that these are the voices we need to hear, the voices of the people, civil society groups, and individuals who are particularly involved. I would now like to address the essential issue that I wanted to share with you today. That is to say, the relationship between the Inter-American Court and the countries of the Caribbean. I also would like to take a look at what I believe to be one of the essential traits of the court, a feature that is not always emphasized as strongly as it should be. An international human rights court is essentially a peace court, a domestic peace, internal peace, in the sense that when human rights violations are identified in the countries as committed by the states, and the states are ordered to make reparation, this contributes significantly to domestic peace. We have also seen advisory opinion 0327 and seen, that is 2317, when we see the human rights implications when there are cross-border environmental damages, and this places an obligation on the state where the damage was caused vis-a-vis the cross-border country receiving the impact of that damage. So that is why I can say that the court is a court of peace, having to do with relationships between the states, and also when there are human rights violations within the state. But this aspect of the court, I think, is particularly critical. The moderator of this panel discussion already pointed out how things stand today regarding the countries that have become parties to the court. We have Barbados, Dominica, Grenada, Haiti, Jamaica, Suriname, and all of these, and Trinidad and Tobago, all of these have signed the convention. Only Barbados, Suriname, and Haiti are now recognize our jurisdiction, our contentious jurisdiction, and also we have Trinidad and Tobago, which removed itself from the convention, which denounced the convention in 1998. I think this is a critical point. Today we were emphasizing in a meeting with the Prime Minister of Barbados that on this occasion, the Caribbean is facing the consequences of climate change. And the court has been called by two countries, which are not countries of the Caribbean, but which nonetheless are very concerned about the subject, that is Chile and Colombia. Again, has asked the court to issue an opinion on the consequences of climate change. And to me, this is an excellent opportunity to emphasize the value of the universalization of the system. That is to say, this is an opportunity to work together, hand in hand, between the court and the countries of the Caribbean, because the court will be handing down an advisory opinion that will be applicable to all the countries of the Caribbean. And it will be especially important for these countries, regardless of whether they have ratified the convention, regardless of whether they have accepted the jurisdiction of the court, because the result of this advisory opinion will be a line of action for the future that the court will be determining in its decision. Therefore, I think there's value of universalization. That is to say, even beyond specific debates that have taken place through history, such as the capital punishment, for example, but now we have elements in common that can clearly determine that the system for the protection, the Inter-American system for the protection of human rights, affects all of the Caribbean. It covers all of the Caribbean, and we can say that in the same way that there are 34 countries in the region, in the hemisphere, that have agreed to accept the jurisdiction of the court. There are also countries of the Caribbean that are equally subject to the jurisdiction of the court, and especially to the convention. I think that this is a historical landmark. It's a critical moment for the court to, in its membership, to represent, to wear the face of the entire hemisphere, all of the sub-regions within our jurisdiction. There have been judges from the Caribbean in the past. Certainly, Margaret Macaulay, who up until very recently was president of the commission. I also remember Judge Oliver Jackman from Barbados. And today the president of the commission is from Barbados, and there need to be judges from the Caribbean on the Inter-American Court. So I will say it again: we need to see this in perspective. We need to see this in the perspective that the coming years will be absolutely essential for all of the regions, especially those that are most affected by climate change, and where we need to, before we reach the limit and start seeing consequences that are irreversible, that cannot be stepped back. Before that happens, we need to determine policies for resilience. We need to determine the ways and means by which it will be possible to make human rights a reality for the entire region. With this, I will complete my comments. Thank you for your attention. And I would like to express my desire that even though it seems to be difficult and overly optimistic, I would hope that we will experience a better world in the coming years. And what will make that happen? The effective exercise of human rights and the commitment of the countries and societies, their commitment to a basic principle, which is solidarity among human beings, and the commitment to leave behind us a better world for coming generations. Not only those who are young people and children today, but those who have not yet been born but are the future of our human race. Thank you.
Thank you very much, David, and I want to say greetings to everyone, of course, especially and welcome to Judge Hernandez Lopez and all of the other members and judges of the Inter-American Court on Human Rights. I want to recognize Solicitor General Ms. Anika Jackson, and of course my co-panelists. As current president of the Inter-American Commission on Human Rights, I'm really pleased to participate, and I also want to recognize my former colleague and friend, Soledad Garcia Munoz, who is recently the Special Rapporteur on Economic, Social, Cultural, and Environmental Rights within the Commission, and I'm sure she's here to be raising lots of questions tomorrow and giving good advice, which she always does. So, hello, Soledad. This year, the Commission commemorates its 65th year in existence, and its engagement and work to promote and protect human rights in the Americas and the Caribbean. And so I just want to give you some numbers as a clue or clues to impact. The Commission has a robust system of petitions and cases in which more than 750 merit reports have been issued and over 220 friendly settlements approved. We have undertaken over 100 in local visits, on-site visits in countries, and with every one of those visits, a long report. More than 1,000 precautionary measures have been granted to preserve life and health of individuals, and 116 thematic reports, 86 country reports, and 15 practical guides, and 8 compendia on inter-American standards, so a whole library of knowledge. The Commission, however, has been very attentive to both its efficiency, that's like reducing the backlog and being more proactive about being timely in the consideration of petitions, and requests of precautionary measures. So we've been concerned about efficiency, but also very much concerned about effectiveness. In other words, we've been concerned about the impact on the lives of individuals and historically marginalized populations in the Americas and the Caribbean. And also how the Commission is able to support and promote the rule of law, and very importantly, democratic institutionality. So in 2019, just to let you know, for those of you who are interested, the Commission created an observatory of impact to make visible and to evaluate the impact of the Commission's actions on the defense and protection of human rights in the hemisphere. And you can all go, the observatory is online, so you can go to the website to look at the reports on impact. So I don't have to see all of that here, but just to give you an idea of some of the reports on impacts, there's a review on impacts of published merit reports on cases on discrimination and violence against women, which was published in 2019. There's a 2023, so quite recent, compendium of academic articles entitled Impacts of the Commission. We have a 2023 compendium of progress and measures of compliance with recommendations, which looks at how member states have been implementing the recommendations that come through the merit reports, but also through the country reports. And more recently, in the framework of this 65th year, we have also published a timeline which shows you the main milestones that have marked the history of the Commission. And I think it's quite an interesting timeline, so please go have a look at it. But I want to speak about some examples of impact, some more specific examples of impact, in addition to these numbers, which I think tell a story of some accomplishment over 65 years. And so I want to speak about issues such as memory, truth, and justice, which the Commission is very much concerned about, how the Commission responds to social crises and social protests experienced over the last decade, and also on gender equality. In relation to memory, truth, and justice, the early years of the Commission's work were marked by military dictatorships in Latin America, by internal armed conflicts, and by serious systematic human rights violations involving forced disappearances, extrajudicial executions, torture, slavery-like forms of constrictions of liberty, and of course gender and sexual violence and gender inequality. Through its protection mandate, the Commission's work has supported the efforts of countless victims, family members, and human rights defenders insisting on truth and accountability. And I want to highlight 2 developments of standards in this area. First, through the work of the Commission, we have the recognition that the right to the truth has a collective dimension. in that societies should know the facts and circumstances in which serious violations occurred for the purposes of obviously non-repetition. So that's the first expansion of that, of the concern, the standards around truth, memory, and justice. Secondly, the Inter-American system, that's the Commission and the Court, has expanded the right of families to know the fate of family members. And the right to know involves seeking and obtaining information on the causes of victimization. So why did this happen? The causes and conditions related to violations of international human rights law, but also international humanitarian law. The progress and outcome of investigations, very important because that's how we're combating impunity. The circumstances and motives of the crime, and motives of the crime, we are very insistent on that, particularly if the motive is discrimination, prejudice, hate, political persecution, so the right to know what is the motive, and the circumstances surrounding the violations, and of course the determination of the whereabouts of victims who have been disappeared or killed, and the identity of those who were involved in the disappearances and or death. So that right to know, which I think is a very big aspect of justice and also reparation, and also takes us towards non-repetition because you have a robust understanding of what has happened and therefore the demand for accountability and justice. There are also concrete examples of impacts related to the activities by the Commission. To give an example, from a historical perspective, often we hear about the visit to Argentina in 1979. I've heard that referenced quite a lot over the last 2 years as I've been involved in the Commission, not only because it received testimonies of thousands of victims of the civil-military dictatorship, but also because the visit of the Commission to Argentina contributed to bringing together the international community to pay attention to the serious violations perpetrated by the Argentinian military regime of the time. So that's one. The other one, in relation to reparations, the state of Peru, in response to merit reports of 185 cases related to a period of violence between 1980 and 2000, so 20 years of violence, undertook in May 2022, so just 2 years ago, a symbolic ceremony in which a piece of land was handed over for the reparation of hundreds of victims of that violence in that 20-year period. And lastly, regarding the massacre of 43 people that occurred in Colombia in 1988, as a result of a friendly settlement many years later, 2015, better late than never, the state carried out a public apology ceremony conducted with the surviving victims, family members, and state authorities, presenting the testimonies of the surviving victims and relatives of the deceased victims. And of course, that's very important to be able to speak your truth and have it understood, heard, and repaired, really important. And so I invite you to read the Compendium on Truth, Memory, and Justice and Reparation in Transitional Context, which was published by the Commission in July 2021. And that compendium brings together the standards developed during the monitoring and decisions of cases by the Inter-American Commission on the rights to truth, justice, and reparations in the context of transitions from dictatorships to democracy, or in the process of search for and consolidation of peace. Okay, thinking about the crises of the social and political crises of the last decade, I would like to refer to the Commission's work around social protests, freedom of expression, and electoral conflicts. The Commission pays really close, constant, and consistent attention to countries in which are experiencing political turbulence and where democratic institutionality is threatened. So we do that through observation missions, close monitoring, and we do that, for example, in respect to countries such as Ecuador, Colombia, Chile, Honduras, El Salvador, Guatemala, Nicaragua, Bolivia, and Venezuela over the last decade. Through the establishment of special monitoring mechanisms, the Commission signals its intention to maintain visibility, but also to give voice to human rights defenders and also extend the possibility of technical cooperation to states. In relation to Guatemala, in 2021, in the annual report, Chapter 4B, the Commission noted serious setbacks in the fight against impunity and corruption, the intensification of harassment and criminalization against members of the judiciary, human rights defenders, and journalists. the placement of Guatemala in Chapter 4B of the annual report, and that's a part of the annual report where countries go where there's been systematic, egregious abuses of human rights at a large scale, or where democratic institutionality and rule of law is severely undermined. So the placement of Guatemala in Chapter 4B was strenuously resisted by Guatemala itself. And last year, when the election results were being undermined, it was acknowledged by the OAS, member states of the OAS, that the Commission's work actually constituted early warning. The trust and confidence in the Commission was also demonstrated in relation to Guatemala in the request for and the granting of precautionary measures for the President-elect in 2023, President Arevalo de Leon. So that's a really very current example of the usefulness of the Commission's work and its impact. In response to discrimination and violence against women, the Commission has identified some good practices that have applied the Inter-American normative framework. For example, the adoption of regulations to prevent and punish sexual harassment in public spaces, as happened in Peru, in Chile, in Argentina. The mandatory training of public officials, and particularly police, but also judiciary, on gender and violence against women. And in this regard, the adoption of the law, Micaela Garcia, in 2018 in Argentina stands out in commemoration of a woman victim of femicide. And that law allows for the training and sensitization of the entire civil service of the state of Argentina on gender and violence against women. And we also have judicial decisions aimed at dismantling discriminatory sociocultural patterns and stereotypes. So, for example, the decision of the Supreme Court of Peru in 2019 regarding the inclusion of a gender approach in a national curriculum for basic education. And we're able to trace the line between the Commission's work and these reforms in law and policy. The Commission has, of course, prepared thematic studies on women's rights and also has been involved in investigation on the situation of women in specific countries in the region. Some of these reports include those issued on specific countries such as Brazil in 2021, Guatemala in 2017, Mexico in 2015, and also include sections on human rights situation of women in more general thematic reports. And we do have a big report, big and important report on violence and discrimination against women and girls and adolescents, good practices and challenges in Latin America and the Caribbean, published in 2019. I want to make special reference to the case of Maria de Pena from Brazil. Many of you know it because I see people shaking their head on that. This case is considered very emblematic of the work carried out by the Commission with crucial impacts on gender issues. So Maria de Pena, for those who don't know that, in May 1983, was the victim of an attempted murder by her then husband while she was sleeping at home. In response to her petition, the Commission issued a merit report in 2001 where it applied for the first time the Belém do Pará Convention in a specific case and issued recommendations seeking comprehensive reparations with individuals and with a structural scope. And that report was also very important in outlining what was due diligence standards for the taking of reports, the investigation, prosecution, and punishment of violence. This was a case of domestic violence. Since then, in Brazil, the state has reformed the domestic legal code and has created the Maria de Pena law, which provides for criminal penalties against aggressors and promotes programs to care for women survivors. Also created agencies and strategies to combat domestic violence. And these changes have made a crucial contribution to the recognition of domestic violence as a crime and also as a human rights violation, and also combating the impunity which characterizes so much of violence against women, and in particular domestic violence. Also here in the Caribbean, we have that terrible impunity. So it's always good to get first-hand testimony. And in relation to the impact of the case on Brazil, Maria de Pena herself said, "What we have today was the product of the intervention of the Commission. Thanks to the recommendation on legislative changes, the state created the Maria de Pena law. This law was so named in my honor for the contribution I made by not giving up this struggle." I love those words. So as I conclude, I think that the relevance and impact of the Commission is also demonstrated in the ongoing demand on it. In 2023, the Commission received 1,133 requests for precautionary measures. and another 2,800 petitions. That's just last year. And I suppose the more we get efficient and effective, the more that there will be a demand. It's a kind of a vicious cycle. We'll have to go and figure out what to do about that, but okay. I think that the Commission is up to the task of working it out. 2 years for me, later after joining the Commission, I have no doubt as to the meaning of the Commission, particularly for Latin Americans. And we are making a determined effort to be equally relevant and responsive to the Caribbean. And as a result, we now have more active engagements with the Caribbean Court of Justice and with other regional institutions. We consult regularly now with civil society and human rights defender organizations in the Caribbean, and we have seen a slight uptick in the number of hearings requested by Caribbean civil society organizations. We've also seen increase in the request for precautionary measures, and we granted to Guyana and Jamaica last year precautionary measures in relation to indigenous peoples and also the right to healthy environment in the case of Jamaica. And just today, we have the wonderful case from Dominica, BJ versus the Attorney General of Dominica, where Dominica now joins the growing group of countries which are finding criminalization of same-sex intimacy to be unconstitutional. And in that case, in fact, the inter-American standards were raised by the lawyers for the claimant. So again, small indicators of impact. In addition to being a system of international justice and a mechanism to build inter-American standards that promote structural reforms, our human rights system, the court and the Commission, has a symbolic value. It represents a listening space for victims who have been silenced. The Commission, I think, is an accountability mechanism. Not I think, it definitely is an accountability mechanism. And more importantly, the Commission can and does proactively support states to meet their obligations through our technical cooperation mechanisms. So with that, David, I want to thank you for allowing me to speak to the Commission's work, and there's a whole lot more that I can say, but I welcome being here with you.
Thank you very much, President Clark, and thanks to Justice Manrique, and apologies for not thanking you after your presentation. I am pleased to welcome Justice Gomez to make a presentation. Thank you.
Thank you very much. First, acknowledgements and thanks first to the government of Barbados for hosting these 166 sessions of the Inter-American Court of Human Rights. Big thanks to the University of the West Indies for hosting this event and the sessions. Thank you. Thank you for being such great hosts. I'm also really honored to share the panel with the two of my colleagues, the President of the Commission, my colleague, Juez Pérez Manrique at the Inter-American Court, and of course, Professor Berry, Professor Desierto, and Mr. Sharma, whom I haven't met, but I'm looking forward to doing that. I cannot start without doing what everybody has done during the day, which is remember, Oliver Jackman, who was larger than life. He had 2 mandates as commissioner and 2 mandates as judge of the court. I think that's the only time we've seen this. I mean, Margaret Macaulay has had 1 mandate as judge of the court, and and 2 as commissioner. But Oliver Jackman was unparalleled, and he was so charismatic. I mean, I had the privilege of seeing him in action in Washington. I was very young then, and then many times as judge of the Inter-American Court. And he was so wise, charismatic, very, very, very clever separate opinions. So go read them. Some of them, we might not agree with, but very, very, very insightful jurist. So I just wanted to remember him in this occasion. That takes me to my prologue. And that's, it starts with a sort of an apology, because I think that judges talking about the impact of decisions issued by the court that they're members of, it's a bit strange. It sounds like propaganda. I had to talk myself, convince myself to do it, because it's a bit of an uncomfortable task. But there are two very important elements here. One has to do with the intergenerational view that we can take on all of this. So it's not really me as a judge talking about the Inter-American Court that I'm a member of. Is speaking about the wonderful legacy of many great judges that went through the Inter-American Court of Human Rights. And it's a relatively young tribunal. So in my case, with my age, I had the fortune of having met them, most of them, since the creation of the court. So for me, it's having a look at the past, at their legacy, and that's really comforting, in this task. And aside from this intergenerational perspective on impact, I want to bring up the interinstitutional perspective on impact in the inter-American system. I don't think it's possible to speak about impact of decisions of the Inter-American Court without thinking of the impact of the work of the Inter-American Commission. It's impossible. It's impossible. Sometimes the way in which the system has been designed, it reminds us of all this debate about the fragmentation of international law, and in particular, the fragmentation of international protection of human rights. That people discuss a lot about. But at the same time, this is a really potent, I would say, example of an organic relationship. It is not a fragmented relationship. I do believe, knowing the Inter-American Commission very well, and I'm sorry that I censored Professor Berry when he wanted to talk about part of my life I spent working for the Inter-American Commission of Human Rights as an official of the Organization of the American States. So I happen to know both organs really well. And I am a big believer of this organic nature of this relationship. So it's impossible to talk about impact of the Inter-American Court without thinking of the impact of the Inter-American Commission. Otherwise, the cases wouldn't reach the jurisdiction of the court. Otherwise, many of the very important questions in terms of advisory opinions have been posed by the Inter-American Commission of Human Rights, especially in the first years of the history of the court. Lots of the protective measures get to the court through the Inter-American Commission. So this is a very, very important perspective as well. The other thing about impact and international protection of human rights is this business about international adjudication and the aspiration of having an impact. And there are lots of questions here, questions that have to do with which are the baselines that we're considering when we want to discuss impact. I think I'm going to come back to this question at the end. I don't think that we can go to the meat in terms of impact without thinking about which are the means that we use to achieve impact. There is no outcome without tools. So maybe we have to understand first which are the tools we've got in that regard. And I think that we need to consider jurisdiction, how the court exercises its own jurisdiction. We need to have a look at interpretation, and we need to have a look at implementation. I think in terms of jurisdiction, there are lots of interesting elements in the inter-American system about how the Commission initially, historically, understood its own competence to study cases, and then how the court, as a younger organ that was receiving cases from another organ that had been alive for longer and that it had a broader jurisdiction in terms of member states of the OAS, how it could interpret its jurisdiction in order to be able to exercise it. And I think the very interesting lessons in international law, very bold lessons on how to understand jurisdiction ratione temporis, for instance, and jurisdiction ratione materia, but in particular ratione temporis, with many, many very serious human rights violations, very, very well described by Roberta, that had a continuous nature. The classic example is the forced disappearance, but there are many others that we can think of in those terms, for instance, displacement, that have a continuous impact that deserves to be assessed by a court. So that's the first element. The second element, I think the great tool in terms of interpretation for all those that have studied the text of the American Convention is the wonderful Article 29. The wonderful Article 29 that opens lots of doors and windows, both for the court, the Commission, and the court, to interpret not only the Convention, but also other treaties, the American Declaration, other instruments of the same nature of the American Declaration, and that's a very good question, because the American Declaration is such a special instrument in international law, and also domestic law of member states. But you'll see that the Commission and the Court have also interpreted domestic law of states outside the region as parameters, of higher standards for the protection of human rights that should be considered, the Convention says, by the Commission and by the ultimate interpreter of the Convention, that is the Inter-American Court. So we should always remember that we have that incredible tool to work with. There have been other tools in terms of interpretation that have been developed by the Commission and the Court, and particularly the Court, all of these intersectional approaches that have been so important to disentangle discrimination cases, especially discrimination cases connected to gender, but also with race and with so many, many, many aspects. So many elements like this, so many techniques to interpret states' obligations in light of evolving standards. The third big tool, of course, has been how the court has decided to address the issue of reparations. The reparation of material damages, the reparation of non-material damages, and how is gone about the issue of non-repetition. There is some consensus that this is one of the big contributions that has been made from the case law of the Inter-American Court to international law. Undoubtedly, it's a very, very important tool for the court to develop its work. The other essential tool developed by the court is the issue of supervision. We have all this, big toolbox, and recognizing the importance of the transformative impact of its own decisions by establishing a procedure that is good enough, apt, to make sure that there is full compliance is essential to the impact of the decisions. And the Commission and the Court have been both very good, but I think the Court in particular, in developing the rules of procedure and their practices in order to increase the impact of the decisions. And this is a very, very important example. Continuing with the supervision of a case, not only in writing, but introducing hearings, introducing in loco observations, which was a very bold step for the Court. The Commission is part of its history, is in DNA of the Inter-American Commission to go and do in loco observations. But in the case of the Inter-American Court, it was a very, very bold step and a very, very important one. And also understanding when maybe to join different cases to observe similar measures that require compliance. I'm a bit long, so I'm going to just mention another very important tool, which is conventionality control. Conventionality control is essential to impact. It's not only essential to impact, it's also what reinforces the legitimacy of the entire process. Involving domestic courts in the enforcement of judgments, even on principles that were applied to judgments relating to other countries, has been essential in terms of the impact of the decisions of the Inter-American Court. One area that is very important, it was mentioned by Roberta in the shape of precautionary measures. One area in which the Court has an important impact is the area of provisional measures, protective measures. Protective measures not only connected to pending cases, but also protective measures in cases where a violation has not occurred, and the purpose of the measure is precisely preventing a serious violation from occurring, particularly when we're talking about the safety, the security of a human rights defender. Sometimes it's somebody working for an NGO, other times it's somebody even working for the state, somebody working in the administration of justice. And this has been, in general, a very, very important contribution of the Inter-American system, developed with similar standards by the Inter-American Commission and the Inter-American Court. I think another very, very important contribution to the development of international law in general. Well, then we finally get there. The contribution in terms of decisions on the merits and reparations. I don't know if I have time, but just to mention, just to get it out of the way, the quantitative approach to this issue. The Court has issued more or less, roughly, very difficult because judgments are coming out all the time, around 380, short of 400 decisions. Only 21 have been elevated to the General Assembly of the OAS as judgments that have no compliance. At least 53 have been removed from the docket of the Court for full compliance. And then we have a large number of cases, 293, which are being monitored as we speak. Many of those are just being monitored for just 1 or 2 pending measures of reparation. And we need to take into account that on average, a judgment of the Inter-American Court, apparently they tell me, the statistic is that it brings between 7 and 17 measures of reparation. So if you have 2 pending, that's actually very good. So although there is a culture of doubting the efficacy of international law and international protection of human rights, I think that the numbers are very striking and very positive. For instance, in the year 2022 and 2023, the court established that there was partial total compliance with 206 measures of reparations, individual measures. Could be publishing a decision, but it could be paying a large compensation. And it held 47 supervision hearings and removed 9 cases from the docket, in 2 years, which is not bad. We don't have a lot of time, but if we had to have a look at more of a qualitative approach, taking one of the more difficult issues, not difficult, complex issues that the Commission and the Court usually address, which is indigenous peoples and their ancestral lands. We're talking, amongst the most, complex cases that the Court has to examine. We're talking about this sort of measures, providing a title, a deed for thousands of hectares of communal lands, expropriation laws for lands held by third parties, signing of agreements through intercultural dialogue, cancellation of mining licenses, payment of compensations, and establishment of development funds, programs for the registration and issues of identity documents, delivering of housing, providing basic goods and services, etc., etc., etc. You can visit the webpage of the Inter-American Court, and there's the two special reports on impact compilations that have been published explaining this sort of measures, so that we can put a little bit of a face or an image to the number. I left for the end the advisory opinions, because that's what we're here for. Advisory opinions are an authorized interpretation of the American Convention, the clearest, not colored by a particular case, but the clearest ones. In advisory opinion number 21, the plenary of the court established that conventionality control extended to advisory opinions. And this has been welcomed by the judiciaries of the different countries in the Americas. And I think it's important to highlight the degree of participation of member states of the OAS in this kind of process. And I don't mean states that have ratified the American Convention and accepted the contentious jurisdiction of the court. I'm talking about states that have not. As from tomorrow, we're going to have even a state that is from outside the region participating in the advisory opinion hearing. These are processes that are very important for the development of inter-American law and international law in general. And it's very important to acknowledge their value. If I have, do I have time to say something? No. No? Okay. Just to say, just to finish, saying that there is a lot of work ahead, and the Inter-American Court is working using all his toolbox, his big toolbox, to address economic, social, cultural rights, and now environmental rights as well. This is very important, using this toolbox in a way in which the American Convention really is a living instrument and really responds to the most important issues of the Americas, and especially those that are connected with inequality, poverty, issues that need resolving. Otherwise, there is no hope for compliance with human rights. Thank you. Thank you.
Thank you very much, Justice Gomez. I'm sorry to have cut you short. If I could now ask Professor Desierto to speak.
Thank you very much, Professor Barry. In the first place, I would like to extend my gratitude to the Inter-American Court of Human Rights for taking the court to the Caribbean, and most especially on the most impactful case on climate change, to take it here and hold a public hearing that is truly inclusive and participatory. I'm also grateful to the Inter-American Commission through President Roberta Clark, who is here, and to the judges who have spoken here in this panel and before whom we will have the pleasure of submitting our arguments or our submissions this week. And likewise to the University of West Indies and to the government of Barbados, represented by Solicitor General Jackson, for convening this international seminar. I have the distinct pleasure of having long been an admirer of the jurisprudence of the Inter-American Court of Human Rights from the time that I was a law clerk at the International Court of Justice, interacting with your famous president, Justice Cansado, Judge Cansado, Antonio Cansado Trindade, who even then had the foresight to anticipate the kind of progressiveness and evolution that was necessary even for the International Court of Justice to revisit the parameters of its own jurisdiction and its interpretive techniques in international human rights law. I also have the pleasure now in my research capacity and faculty capacity at Notre Dame to also be able to interact with the court's jurisprudence and especially its reparations work through the Notre Dame Reparations Design and Compliance Lab, which I co-direct with my colleague Anibal Perez Linyan. We have been very grateful to work with the court and the commission for the last 4 years in providing the kind of social science analysis and legal analysis to ensure that we could help support the work of the court in its own perennial reflection, institutional reflection on the effectiveness of its reparations measures. My task today is to talk about emerging trends in international human rights law. I will pay specific attention to the emerging part and talk about developments just within the last 5 years in international human rights law. And I see that there are 2 primary developments, and contrary to the long arc of scholarship that has pointed out the fragmentation of international law and the fragmentation of human rights law, and especially of mechanisms to protect human rights law. What I see from the last 5 years is a growing convergence towards a lex generalia, where international law is actually being transformed not just by the normativity and institutions that are created in international human rights law, but the expectations of human rights outcomes that are perennially shaped and animate the lawmaking process as well as the interpretive and adjudicative process. So on the first point of increased normativity, we have been accustomed to looking at the 9 major international human rights treaties in the universal system as encompassing or elaborating the fundamental purposes of protection and recognition of human rights under Article 1, Paragraph 2 of the Charter of the United Nations, and Article 55 in relation to Article 56 of the Charter that requires joint and separate action by states as well as the United Nations to realize, respect, and promote human rights. Hersch Lauterpacht, the famous lawyer, in fact, argued in 1950 that it was not necessary to elaborate any further instruments on human rights law because in the end, this is what unifies everyone. But we find that the same result, I would argue, in 2024 is being achieved even if there has been so much elaboration. We are tending towards a convergence of human rights treaty standards. So beyond the 9 major human rights treaties, the very important regional human rights treaties, especially in the Inter-American system, we now see growing convergences of human rights provisions that are now being directly incorporated in other treaties. not just in the usual sort of human rights adjacent treaties such as the ILO conventions, but also in investment treaties, in trade agreements, in economic partnerships, the new generations of agreements that specifically require compliance with human rights, labor, and environmental commitments, apart from the economic commitments or simultaneously with the economic commitments that states are taking on. The Morocco-Nigeria bilateral investment treaty is a model of that. The CETA is also a model of that. The ongoing discussions in relation to CARICOM's regional economic partnerships also place central importance on preserving and ensuring that states have a right to regulate that protects existing international human rights commitments as part of the commitment to sustainable development. We also see that even in the spaces of maritime law, on the law of the sea, which no doubt is of distinct interest here in the University of West Indies, which is a famous university for conducting these studies, we see so much elaboration of human rights law, not just in relation to the traditional expectations of marine environmental protection that we already find in the UN Convention on the Law of the Sea, Articles 192 to 194, but we also see it in the new treaties that have emerged from the BBNJ Treaty that also looks at the sharing of marine genetic resources and these issues of equality and participation and justice and the access to these specific resources. And we also see it in the elaboration and interpretation of what it means to have a common heritage of mankind and how that coincides with the understanding of human flourishing that is supposed to attach to our fundamental dignity as humans. We see that in the increasing push towards global commons regulation that is more in accord with the expectations of non-discrimination and the fundamental duty, for example, in the Covenant on Economic, Social, Cultural Rights, never to deprive any people of their means of subsistence, and how the resources are allocated in the global commons are increasingly being pushed towards those very same expectations of human rights that have long been internalized, have long been practiced, and cyclically implemented throughout different international human rights treaties. Even the convention in 2017 on nuclear non-proliferation states the aims of a right to peace, which famously here in the inter-American system is recognized fully as part of the corpus of international human rights law. A project that I have been a part of, along with a distinguished former president of the commission, as well as a member of the court, Judge Margaret Macaulay, is the forthcoming 10th Human Rights Treaty, the Covenant on the Right to Development, that was approved last year by the Human Rights Council for transmission to the General Assembly, where it is currently pending and being reviewed at the 6th Committee and requires 20 signatures from states for its adoption. And this is where I see that the Lex Specialis is actually moving to a convergence, because in this forthcoming treaty, the very definition of the right to development that was instantiated in the 1986 Declaration on the Right to Development has since been revised to reflect a right to development that is a right of individuals, of groups, of peoples to participate in, enjoy, and contribute to economic, social, cultural, civil, environmental development in a manner that is indivisible from, interdependent with, and interrelated with all other human rights and fundamental freedoms. That is the first elaboration of normativity that looks to address or provide a textual mechanism for gap filling in international human rights lawmaking, drawing on the simultaneous applicability of international human rights law. So that's within the last 5 years. From the jurisprudential side, anybody who has been following developments at the international courts we'll see very readily that something that is quite normal for the Inter-American Court of Human Rights, taking as many cases in its docket that it does, with the degree of complexity that it does, is suddenly besieging the International Court of Justice that did not used to have a very big international human rights docket. We see from the Genocide Convention cases, the contentious cases, where in 2007, in the Bosnia v. Serbia case, the court raised the threshold for what is a duty to prevent genocide to make it virtually difficult to ascertain whether or not a state incurs international responsibility for failures to prevent genocide. We see that there have been tectonic shifts in how the International Court of Justice has interpreted the nature of collective interests in the performance of obligations under the Genocide Convention, beginning with the Gambia versus Myanmar's judgment on jurisdiction, which permitted for the first time a treaty party which was not itself experiencing genocide to bring a case against another treaty party in the Genocide Convention, Myanmar, for its failure to prevent genocide that was being committed against the Rohingya. The court granted the application of the Gambia to represent that interest as a collective interest, as an interest in the good performance of a treaty. I actually thought to myself, it's not unlike this court's jurisprudence that anticipated collective interests long before the International Court of Justice ever did so. And we see subsequent developments in the same realm of genocide cases. The South Africa versus Israel case, which is pending and which has issued landmark orders of provisional measures, and most recently the Ukraine v. Russian Federation judgment on the merits, which initially was very promising in terms of its wide admissibility decision, but in the end managed to whittle down in its interpretation of Article 9 of the Dispute Resolution Clause in the Genocide Convention, managed to whittle it down so much that it places the currently pending cases, Nicaragua versus Germany and South Africa v. Israel, in real question and as to whether or not it will survive the merits. There are also the many contentious cases involving the covenant, or rather the Convention on the Elimination of Racial Discrimination. We saw the landmark merits judgment in Ukraine versus Russian Federation, where the court, in its merits decision this year, actually issued its finding that there was a violation of the economic, social, cultural right to education by the Russian Federation. We see also in the Armenia versus Azerbaijan cases so many provisional measures orders that look astonishingly familiar in the kind of provisional measures that are being ordered. At some point, I think of it as the law review article I want to write, the great similarity of reparations orders that actually, many of which you already see from the Inter-American Court of Human Rights, but which are only starting to penetrate the International Court of Justice. And there's also, of course, the Convention Against Torture proceeding that resulted in a provisional measures order in the case of Canada and the Netherlands versus the Syrian Arab Republic. This, apart from the two pending advisory proceedings at the International Court of Justice, one on climate change as well, and the second on the right to strike under the International ILO Convention number 87. That's a human rights docket that emerged just within the last 5 years. The Inter-American Court has continued to lead as well, and much as there's so much jurisprudence, rich jurisprudence, let me just point out two landmark, as very significant decisions that the court has issued within the last 5 years. Just recently, this year, La Oroya versus Peru, where in that decision, the reparations that the court granted for the environmental contamination from mining activities truly approached this notion of continuing harm by requiring such a strategically lateral approach to how the government was going to require not just remediation, but also continuing responses to the health concerns of the constituents who were most affected by the contamination. There was also the famous La Cajon Hat case versus Argentina, where in the judgment on the merits, the court for the very first time, as pointed out by Judge Gomez, declares a right, or rather orders Argentina to recognize title for a unique communal property of about 400,000 hectares for land inhabited by indigenous peoples. Later on, the African Court on Human Rights will actually also emulate this principle on land restitution in its famous case, the African Commission versus Kenya, Judgment on the Merits, where its judgment on reparations also recognizes the non-pecuniary measure of land reparations, granting collective title to indigenous ancestral land of the Ogiek community. We see a parallel as well in the judgment of the sister regional court, the European Court of Human Rights, which just a few days ago issued the first judgment on a contentious case involving climate obligations, which no doubt the public hearing might hear about very much. So to the point of, at least to me, establishing state responsibility to mitigate not just territorial emissions, as well as embedded emissions. This is a first in the jurisprudence on international human rights. Also, within the last 5 years, more like last year, the European Court on Human Rights elaborated in its 2023 judgment on the human rights, most especially the economic, social, cultural rights of migrants, whether they be maritime migrants or land-based migrants, in the case of JA and others versus Italy. In my remaining time, I would like to invite your attention to the trends of what I see are recurring issues involving international human rights law. The first involves how we look at legal consequences ensuing from intersectional harms, especially in non-discrimination. It raises serious questions now about who are the rights bearers and how do we design redress? How do we attribute responsibility between state and non-state actors that create these continuing harms? And what's the appropriate reparative design for continuing harms, which very few in the International Court of Justice has certainly not spoken about, but so much has come from the jurisprudence of the Inter-American Court. There are also debated approaches today about whether or not the body of law that we have is sufficient to extend the kind of distinct or specific protection that is needed for certain regimes. And I'm talking about the standard protections that we expect for international human rights law, even during armed conflicts, separate from humanitarian law protections. Protections for cross-border displacement of vulnerable groups such as children and refugees and persons of Afro descent. Protections for those who are impacted by cross-border connectivity projects and other economic activities that are engendered by global value chains with cross-border impacts. How, for example, will artificial intelligence and the kind of displacing effects of technology weigh in on current international human rights law that never anticipated these technological developments? And probably something that is, of course, very resonant, the question of whether there are sufficient protections from our body of law for states that increasingly rely on multi-textured emergencies to justify derogations and limitations on human rights. Your standard national security situation categorizing new forms of terrorists, whether they be priests or human rights defenders or a perceived dissident group, pandemics and economic crises and shocks, and potentially even the climate emergency that we see today, where some are experiencing, such as small island developing states, experiencing the kind of imminence and risk that is more real than it is to most of the rest of the world. There's also the question of whether there's enough in international human rights law to truly protect journalists, when we've seen the very same defenders of human rights, journalists, human rights and environmental defenders, judges and lawyers, directly being attacked under the guise of protections in a state of emergency. All this also leads to the last theme, which I find also an emerging trend in jurisprudence, which is the notion of international human rights law and how we repair when there is a breach. What is the form of reparation? The conventional approach is that which is taken by the International Court of Justice in DRC versus Uganda for a whole slew of human rights, egregious human rights violations, even crimes against humanity that went on for 25 years in the Great Lakes armed conflicts. The court in the end throws up its hands and says, we will assign a figure because this happened so long ago. We will simply assign the figure of $330 million as somehow compensation, pecuniary measures, some form of symbolic compensation for 25 years of lived human rights harms and deprivations. But then there is hope, because the practice of the Inter-American Court of Human Rights, the African Court of Human Rights, the UN treaty bodies suggest, at least within the last few years in its emerging trends, that our judges, our jurists, our adjudicators in the international system have the imagination required to restore, to repair, and ultimately to avoid harm. Thank you very much.
Thank you, Professor Desierto. If I could now ask Mr. Sharma to present.
Thank you, Professor Berry. Thank you to my fellow panelists. I'm glad I could join in time to hear all of your submissions, which were excellent. My thanks to the Inter-American Court and its Secretariat for sitting me on this distinguished panel, and of course, my warm thanks to our Bajan host and Solicitor General Jackson, as always. Today's seminar topic is the impact of international human rights. And I thought I might narrow the focus to what I consider to be one of the most problematic, philosophical, and historical errors in our conception of international human rights that threatens its impact, that threatens its effectiveness. And this is the philosophical and historical error that's composed of two ideas. The first is the idea that international human rights law finds its historical origin and its philosophical origin exclusively in European Enlightenment thought. And the second is the related, it's not logically related thought, but it's a related thought that as a result, international human rights law is inapplicable to, non-integrable with, non-European cultures and traditions. Now, I know there's been a lot of debate about this cultural relativism point for about 30 years, but I think it's coming back, and I think it's coming back with force in a lot of ways. I know I was introduced by Professor Berry before I could run onto the panel, but just so you know who I am, I'm a partner at a law firm called Volterra Fietta. We are the only law firm in the world exclusively dedicated to the private law firm in the world, exclusively dedicated to the practice of public international law, which is the law that governs relations between sovereign states. We practice in all the multiple fields of public international law, international humanitarian law, international investment law, arbitrations, but also in international human rights law. I was pleased to note I was counsel on several of the cases Professor Desierto mentioned, the third case for the United Arab Emirates, and I was counsel to the Democratic Republic of Congo in the armed activities case. So when I'm speaking, I'm not speaking as a professor of law or as a judge or with that august title. I'm speaking as a practitioner in the field on a practical basis. And one of the things as a practitioner I think is clear, but also I believe the judges on this panel and my fellow panelists might agree, is that to be impactful, to be effective, it is not sufficient for international human rights law to only be considered and deliberated and pronounced at such august high bodies as the Inter-American Court of Human Rights. The goal, the purpose of the Inter-American Court, the European Court of Human Rights, the International Court of Justice, they're absolute necessities to our system. But from these upper perches, you have to draw a chain down to domestic legal institutions, to states, and to the state institutions, especially the judiciary, but also their legislations and their statutes. So there has to be a chain from which the excellent judges at the highest levels of our international order render decisions which get translated somehow downwards to good judges at local courts, parish courts, county courts, municipal courts. This magnifies the effectiveness of international human rights law, because if it's much easier for someone to get relief in a judicial sense if they only have to walk a few miles to the local court. Judge Perez-Manrique mentioned, of course, that the Inter-American Court of Human Rights has a kind of quasi-appellate jurisdiction in contentious cases. It hears the cases that filter up. But the vast majority of cases involving human rights could never filter up all the way to the Inter-American Court. So the power of the Inter-American Court lies not only in its contentious jurisdiction, but also its persuasive authority. And that's across the board. The problem with this idea of cultural relativism, this two-pronged idea that human rights law is European in invention and thus non-applicable to non-European contexts, is that it is an attempt to cut the chain from the highest institutions in international law to their domestic entities. It's a scissor by which people with an interest against human rights attempt to say this is not applicable to us, we'll handle this ourselves. And one of the things we need to, cultural relativism, it's always raised in the East Asian context, South Asian context, Arab and Middle Eastern context, but I'm from the United States. In the United States, conservative jurists are basically arguing cultural relativism when they seek to exclude international law from the consideration of US judicial decisions. They're saying this is an alien system to us, we'll handle this within our own constitutional order. And that's always done for the purpose of repressing human rights, repressing the rights of people, juveniles not to be executed, or gay and lesbian, LGBTQ individuals not to marry. It's always done for that purpose. But that two-pronged idea, that human rights law is European in fact, and thus non-applicable outside of Europe, is incorrect in practice, and it's incorrect in actual history. First, with respect to practice. Now, as I said, I'm not a professor. I don't go out to surveys. But I know from my experience that one of the components of my practice as a law firm is sovereign states across the world in various cultures hire me to seek to implement human rights obligations into their national laws and their national institutions. And that can be as far off as international humanitarian law and armed conflict law, all the way to national literacy standards in order to comply with conventions and treaties dealing with literacy. How could it possibly be that all these sovereign states and all these cultures that are meant to be non-European, thus don't know human rights, are working so hard to implement human rights into their own practices? The idea that it's inconsistent with human rights, it's inconsistent for their cultures to adopt human rights, is disproven in a practical aspect. And if you look at the great civilizations of the world and you try to divide them up as Samuel Huntington did, isn't there always an example of a state that practices human rights at a high level? Not the highest level, but there's always one at a high level. The Japanese judicial system, the Indian judicial system. There's always an example of a state that somehow accommodated their alien culture in Europe, so-called European traditions. As a matter of fact, there has been this gross misconception, even among proponents of human rights, that human rights as an idea, international human rights as an idea, emerged from European thought and the Enlightenment. I think this is a very narrow conception of history. It's more a selective reading of history than it is actual. And it's found everywhere. I know today is Earth Day. Yesterday was the 300th anniversary of the birthday of Immanuel Kant, the philosopher whose ideas quite probably determined much of the content of our international legal order. By happenstance, as I was preparing this presentation, I read a New York Times editorial on his birthday, and the writer, who was a proponent of human rights, ended with the following paragraph, which I thought was grossly incorrect and egotistical. He said, quote, The problem with ideas like universal human rights is not that they come from Europe, well, that's wrong, but that they were not realized outside of it. That's wrong too. Perhaps we should take a lesson from the Enlightenment and listen to non-Western standpoints. That's the only thing he said in that paragraph. That's correct. The idea that universal human rights comes only from Europe, I can disprove in a minute. I'm from South Asia. I have South Asian origin. I know of a text, which I read as a child. It's a philosophical religious text called the Bridyanka Upanishad. Right? It's 3,000 years old, literally 7th century BC, or 8th, depending how you date it. And it has a following line, quote, "The law is the means by which the weak chain the strong and drag them across the ground." That's 3,000 years ago. We have the equivalent expression today in English. We say we drag someone to court. Right? So 3,000 years ago, in a philosophical text that is of great importance in South Asia, there's international human rights law and judicialization of that law summed up in a sentence. If we did the studies properly, we would find the same throughout the world. Sharia law is the instrumentalization of human rights law in an area of the world that didn't have it by the Prophet Muhammad, peace be upon him, with universal application. We can't talk about the Barbados briefings to the ICJ, unfortunately. But there are indigenous traditions which, if you grant them the power of law, the power of being part of customary international law, are equivalent. In Africa, in the United States, in Australia. So when people say, human rights law is a European conception, it's not that the Enlightenment didn't introduce human rights law to Europe, and then Europe happened to colonize the world. That's true, but it's not the full story. History persists in truth, even in the face of selective ignorance about it. I'm just going to conclude by saying that there are two other philosophical attacks on the impact or effectiveness of international human rights law that are arguments that are made that, in my view, are also incorrect. These are my names for them. Bureaucratism. That's the idea that instead of concentrating on human rights law, developing countries should have a single-minded focus on institution building and building the power of the state, and that it is somehow inconsistent with human rights law to do that. That if you start putting human rights law in, the army will be less powerful, the police will be less powerful, the judges won't be as good, and so we wait. The other is developmentalism. That's the idea that human rights are a nice icing on the cake once you're rich enough, but that you need to economically develop first and then introduce human rights. That human rights stand in the way of economic development. And I would posit to you that these two theories, which you've heard of various ways, are actually just cultural relativism, and they assume cultural relativism. Because they assume that in these countries and in these traditions, human rights stands as an obstacle to both the institutional development and the economic development of the country. And we happen to be sitting in a country today, right here today, which proves the opposite. Because although the English had great institutions, if you look at the advance of Barbados, if you look at the advance of other countries in this world that have successfully implemented human rights, but also had economic development, it also had institutional development, it disproves these theories as well. With that, I just want to thank all the panelists and conclude.
All right, thank you very much, Mr. Sharma. I have been given the task of offering some closing remarks, and I'd like to try to bring together some of the themes that have come up on this panel. I should disclose for transparency that I am both an academic and a practitioner, so I was able to assist the government of Barbados in one matter before the Inter-American Commission on Human Rights and two contentious cases before the Inter-American Court on Human Rights, as well as an advisory opinion. So I sometimes wear both hats. Now, in trying to draw what has been said by the other panelists, draw them together, you'll see a couple of fundamental things. First, the Inter-American system of human rights is robust and far-reaching. The recommendations of the Commission, the decisions of the Court have profound impacts upon the entire Americas region. But I would like to offer sort of 4 comments. And one, I'm going to put together what Mr. Sharma, Justice Gomez talked about as the international law and the domestic law divide. And I think that in the Commonwealth Caribbean, Barbados is the only Commonwealth Caribbean English-speaking country to accept the court's contentious jurisdiction. And Barbados is what we call a dualist legal system, which means that under our law in Barbados, an international decision is like any other international act, a treaty. It's not binding upon the domestic legal actors, the Comptroller of Customs, the Director of Public Prosecutions, etc. It's binding upon the state as a whole. In order for that international legal act, a decision of the Inter-American Court of Human Rights, to have effect in domestic law, to be relied upon by domestic actors, it has to be transformed. And we usually do that by legislation. And so when Justice Gomez talked about conventionality control, I thought that was really profound to show the differences between common law jurisdictions, where we have to do the extra legislative action, and civil law jurisdictions, where sometimes an international decision, treaty, etc., can be automatically implemented in domestic law. And so I think we have to look at the distinctions between our 2 legal systems. I would urge, of course, more common law jurisdictions to accept the Inter-American system, and to not only ratify the American Convention, but to accept the jurisdiction of the court, and then to do the additional actions necessary if a judgment comes down against you. And I had a role after the Boyce case, where the Inter-American Court said that our compulsory or mandatory form of capital punishment was not permissible under the Inter-American system. We had to change our laws. And so I sat on a special committee to help the Attorney General at the time decide how to do that. And I think states need, in good faith, to undertake that task. So that was the first point, an urge to more English-speaking Commonwealth Caribbean states to accept the jurisdiction of the court. The second point is really to highlight some of the things that have been said earlier. One is the treatment of due diligence. The second is the profound nature of the advisory opinion competence of the court, which I think has partly come out today, but maybe not as far as it can. And then also finally to wrap up on looking at the extraterritorial scope of the Inter-American Court's jurisdiction and how influential that may be. So first, the due diligence. Roberta Clark, Justice Manrique both mentioned that the Inter-American system was born out of a period of fire, dictatorships, internal armed conflicts, where the rule of law and due process were far from established. And it's in such a context that we find this incredibly profound judgment, the Velazquez-Rodriguez case, Velazquez-Rodriguez against Honduras. And this involved the disappearance, I used to teach this to my university students, the disappearance of a university student. And it was proved by, or at least alleged by the commission, and I think accepted by the court, that he was arrested without a warrant by police and military officers, was severely tortured, and was disappeared. And for those of you who haven't heard this term before, disappeared means that you literally are murdered and disappeared. Your corpse is never found. You are wiped off the face of the earth, which is a serious human rights violation. And the commission presented compelling evidence of this. The court eventually determined, sorry, that was not my time. The court eventually determined in its judgment that Honduras was itself responsible for these violations and ordered compensation and reparations. And so that's what we would call in common law jurisprudence the ratio, the deciding element of the case. But I think the most important part of the case, which is I think the profound part, is one that we would call obiter dicta, something that the judges say on the side. And the court asked itself, what if Honduras wasn't directly involved? What if the government agents themselves had not done it? And the court broke new legal ground here by holding that Article 1 of the Convention, which requires states to ensure the human rights in of the American Convention in their territories, creates liability even if the actions were not done by the government itself. And the phrase used here was the lack of due diligence to prevent the violation or respond to it as required by the convention. So the court said that the state here, in this case, was under a legal duty to investigate, attempt to prevent such human rights violations, punish them, even if committed by private persons, private citizens. And this means that a state can be liable not only for its own acts, the acts of its agents, but also for acts of private persons, including natural, and I would submit, potentially juridical persons, companies. And you'll see why I emphasize this. So the next point I would like to make is the far-reaching advisory competence of the court, which I think people may not understand more broadly. I think the Inter-American Court is unique in that it has been given the authority to interpret not only its own treaties, the American Convention, but also, and I quote, other treaties concerning the protection of human rights in the American states, Article 64, subsection 1. In one of its earlier advisory opinions, the other treaties advisory opinion, the court interpreted this phrase very broadly and in a non-restrictive manner. And as held by the court in its subsequent advisory opinion on environment and human rights, in paragraph 7, the court said, in general, the advisory jurisdiction of the court can be exercised with regard to any provision dealing with the protection of human rights set forth in any international treaty applicable in the American states, whether it be bilateral or multilateral, whatever the principal purpose of such a treaty, and whether or not non-member states of the inter-American system are or have the right to become parties thereto. So the court in its advisory jurisdiction can look at any treaty to which an inter-American state is party with respect to that inter-American state's human rights obligation. And this is an incredibly far-reaching scope. So the final point I'd like to make, and I think it's particularly relevant to the subject of the advisory proceedings starting tomorrow, is that the court has concluded that inter-American states can be responsible for activities occurring outside of their borders if there is a nexus of jurisdiction and control between persons affected and the inter-American state party. As noted by the court in its Environment and Human Rights Advisory Opinion, and I quote, the use of the word jurisdiction in Article 1, subsection 1 of the American Convention signifies that the state obligation to respect and ensure human rights applies to every person who is within the state's territory or who is in any way subject to its authority, responsibility, or effective control. Responsibility, therefore, can arise for actions and omissions. Remember, due diligence, the Velazquez-Rodriguez case, and in environment, the duty to prevent environmental harm within a state's territory or outside of it in relation to persons under the state's jurisdiction. Further, a person subject to a state's jurisdiction can include someone who is harmed by acts or omissions of the state. And this has striking implications. And other courts, such as the European Court of Human Rights, have not been able to go so far in their jurisprudence. The European Court of Human Rights, in its recent case, used some not happy words about the Inter-American Court's jurisprudence. But I'm hopeful, like my learned friend here, that there will be convergence, as Professor Desierto had suggested. So, but let's take this and package it together. Applied to transboundary harm, for example, a state may be liable for such harm outside of its territory to a person harmed by its act or omission. In such cases, the victim is deemed to fall under the state's jurisdiction. The state's act has made the person a victim, therefore the person is under the state's jurisdiction for which it has responsibility. So to sum up, the Inter-American Court of Human Rights has issued decisions that have bold implications for state responsibility, not only for acts occurring in their own territories and done by organs or officials, but for acts occurring anywhere, potentially caused by private parties, and can be directly challenged by persons who have been harmed. So first, I would like to end there and just thank my panelists for all of their contributions tonight, and thank the audience for your active attention, and I will close there. So thank you very much.